With the general election less than 123 days away, some issues still linger around the candidates of some contestants. Apart from presidential candidates that do not have issues in court over the outcome of how they emerge, so many governorships, senatorial, federal, and state houses of assembly outcome of primaries are still in various courts yet to be decided. As a result, there is no campaign going on with respect to these offices because the courts are yet to determine these matters almost 6 months after primaries were conducted. This morning, we shall be examining the increasing role of the judiciary in determining almost all political matters and the implication for the independence of the judiciary. Are judges demonstrating courage by doing justice to all political cases before them? How have they handled various pre-election cases that emanated from the party primaries in various federal high courts across the country? There were reports of acts of impunity of political parties leaders who, contrary to Section 29, and reports of INEC state monitors submitted names of individuals that didn't participate in party primary elections as required under Section 84 of the 2022 Electoral Act. Joining us right now this morning on this show as we examine these issues and more is Mike Igini, former INEC resident electoral commissioner, Akwa Ibom State. Welcome to the morning show.
Thank you, Ruben and Rufai, for
let's clarify something, because in the intro I was talking about the judiciary. I thought the Electoral Act opposed the fact that election matters are sui generis and that pre-election matters will have to be concluded within 180 days. And that the 180 days with regard to some of the primaries that were held in May, June, will lapse in November. So what do you think are the issues here that some people say, oh, some other, aspirants, they couldn't campaign because the matters have not been determined? Do you think that the courts will go against the framework already provided, and what will be the implications if they were to do so?
Thank you very much, Ruben and Rufai, for having me. As part of my commitment since I left office, that what I want to do going forward in 2023 is to help educate Nigerians on the basis of the experience I've gained for 10 years. The issue you raise are quite very weighty from your intro. And first, I want to say this here, that over time, I've expressed concern and worry over my constituency, the judiciary, over the way and manner political cases have been handled in this country since 1979, more precisely. But first, I want to say this here to all my colleagues, that before you become a judge, you must first and foremost be a lawyer. And that the very first indigenous lawyer of the Federal Republic of Nigeria, Alexander Christopher Williams, Sapara Williams, he told us, who was sworn in court to the bar in 1879, that a lawyer must live for the direction of his people and for the advancement of the cause of his country. This is had been my votary. That how do we make this country a better society? How do we make Nigeria a country that will work for everybody? If it is well with the hunter, it will be well with the hunter's bag. That's what Roman says. Where we are today, with respect to the issue you have chronicled, it reminds me of what Awo was saying, that look, whenever sometimes we think that the new dawn has come, when he said in 1986, that we may be disappointed. Ruben, as part of the effort to deal with the crisis of having people into offices without resolving the matters, efforts were made to strengthen the 2022 Electoral Act that now effectively the bill repealed the 2010 Act. Profound provisions were made to strengthen internal party democracy. As you, from your background, all of those laws were seriously violated. On that, this year, the Chief Judge of the Federal High Court issued a practice direction, pre-election practice direction. The first objective of that practice direction was that to ensure expeditious disposal of all pre-election matters. And that was why the commission gave a long window so that when these matters are concluded before that election, we will know who are the candidates for that election. As we speak today, and regrettably, if we look at what has happened, Section 285 of the Constitution says 180 days, which was you talked about. From there, you go to the Court of Appeal, 60 days, 2 months again. Then Supreme Court, because all these matters will go to the Supreme Court of the Federal Republic of Nigeria as pre-election matters. This is where we are. We have just 122 days to the opening of the first poll in February. Reuben, many of these cases are still in court. In fact, why should we even give 180 days, which means 6 months, half a year? We just saw in Kenya, a presidential election matter was determined within 2 weeks. But here we are talking, the whole purpose of the design of the 2022 Electoral Act is being aborted. The Federal High Court rule I was even talking about stated clearly that in order to ensure that all these candidates are known before the election, we must have, for anybody suing as parties under Rule 3 or 2, you must ensure that all necessary parties are sued. But today, people go to court to go and try to get judgment on behalf of outcome of primaries without getting other people to be aware of it. Furthermore, under that rule now already being violated because the court itself is supposed to be the custodian to defend its own rules. The rules itself says that you must swear to an affidavit of non-multiplicity of suit. That is not happening. But far more important, within this rule, as I close on the rule, is the fact that under the current pre-election practice direction, all pre-election matter must be commenced by way of writ of summons. But what do we have today? I know of cases in court where people, despite the clear provision of this 2022 pre-election practice direction, they go to court trying to file by way of writ of by way of summons, affidavit. All right. Yeah. Now, the danger we are having here is this, and I chronicle how this has already been happening to us. Recall that we had 2 senior advocates, the current governor of Ondo State and one senior advocate, Jegede. The Jegede candidate, the primary that was conducted became an issue. The matter was not resolved until 48 hours to that election. Why should that be? The consequence of that was that he could not submit party agents. He could not participate in the televised channels television debate. We have got to a level now, Reuben, that all these cases are ongoing. Nothing is being done, and we are heading to election. We are going to have a situation where, like in Bayelsa State governorship election, in Imo, where the candidates were not even known before the election. The whole purpose of the 2022 Electoral Act is now already being defeated. The question is, why are we warehousing these matters in court? Very serious is the fact that we now see here presidential candidates making promises and proposals to Nigeria to change the trajectory of our country. But most of the issues they are raising, they are in the Constitution. But you don't have members of National Assembly campaigning at the moment, because the campaign, the promise made by presidential candidate in any election is not binding on the members of the National Assembly around the world. When you are going to the legislative arm of government, you campaign on issues that you are going to turn to legislation. That is not happening. And that's why in our country, you will find a president of the same party having majority in National Assembly, but they are not able to work together because they never campaign on same issues. This is the time that all those who want to go to National Assembly, State House of Assembly, I mean, you just got a report that the current amendment had been stalled because several states are not in tandem with the proposals. The question is, when they were elected in 2019, did any of these people campaign on any issue for which they were voted for? This is my worry, that I get the background of all of this. That the judiciary, my constituency, is where I have my greatest worry as we go for the 2023 election. Because one would have thought, because it meant that where we are now, most of these cases will not be determined. For example, let's use where I had worked before. They had over 30 cases. 30 cases. None have been, apart from one we heard about in Port Harcourt, have not been decided. So if they decide that by this month, and by next month they go to the Court of Appeal before Supreme Court, it meant that before that election, many of the candidates will not know who they are, and that's why they cannot campaign at the moment. This is dangerous. This is my worry. And that is why we begin to see, my worry more is that we are getting the court more involved to answer even political questions. Ordinarily, in sane jurisdiction, the question of who should be a candidate in an election should be a question for political party ordinarily to determine. But because of what we have seen in this land, is the reason why the 2022 Electoral Act was enacted to curb all of this. But here we are, that we are going for election. Only presidential candidate making promises that will have impact, not to be done in the constitution, will not have people at the state level, national, campaigning because the matter are still in court. This is my worry.
So just to further buttress that, there are litany of cases. Ogun, for instance. So what happened recently in Ogun, a lot of back and forth. If you even saw the case with Obowori in Delta, that even after the case has gone to Supreme Court, there's another one coming up now, still against him. You know, there's another one, some have been decided in the court, and there are many of these cases. And it is coming home to roost. Even the one as regards the judiciary giving, you know, some politicians that might want to scuttle the process, that leeway of getting those, you know, court orders in favor against the electoral process itself. I mean, what's your read on that? Yeah, you've talked about Shakari Williams saying we must be able to build our nation. I mean, our expertise should be in building our nation. The law should be helping us to build that. But you have, you know, pointed out these fears just like the COP too. What are we doing as regards all of that?
Rufai, my call is to my constituency. That remains my greatest worry. And my worry has a historical background to what is going on. What is so difficult in determining who has won election, given that INEC now has reports of all primaries are required under the current act. This is my worry. The expanding empire of the courts. Is the court living up to expectation? Remember that since 1979, when we talk about the confidence when it comes to political matters, I want to say here that the level of courage demonstrated by my constituency when I was much younger under the military, I am not seeing that happening right now. I am not seeing that happening right now. We have very extremely brilliant, fantastic individuals in the judiciary. But there's a growing number of some of my colleagues who are not living up to the oath of office. It's worrisome because we have been on this crisis of judicial recession for a very long time. So when Awo, known for his voting for due process, made the point at the 1983 election that he was not going to court, And when he was asked, he said he had no confidence in the judiciary because of the saga of the 2013 decision that they even said must not be binding. Look, why is that we are in a country that anything that works, that will make the country better, we work against it? In 1979, all cases were disposed of before people were sworn in. In 1983, it is the same thing. My concern here is not about who wins in this plethora of cases that have been warehoused, but the fact that they should be decided. You saw how a governorship election of Bayelsa, the candidature was not known before the election itself. That's the level we have regressed in our country. You saw what happened in the senatorial election. It was not known before the election. This is where we are heading to again. That senatorial, federal, state house of assembly, no campaign going on any issue because they must campaign to complement the proposal being made by the presidential candidate.
Igini.
This is my worry.
Igini.
And that my constituency, you must stand tall and mighty in defense of the rule of law.
Your worries are legitimate.
I must not pander to vested political interests.
Okay, good.
I am worried.
Yes.
I am disturbed.
No, your worries are legitimate. But when you keep saying the judiciary, I think, some people on the bench may feel, you are just putting them on the spot. These judges, they are overworked. They are underpaid. Most of the courts do not have the necessary technology or human resource to deal with the matters before them. But the principal point about treating the matters expeditiously, yes, that's fine, within their capacity. But the second issue is about lawyers. Because, it's not just the bench. All these lawyers that are going about, they don't know how to file matters in court. They will waste the time of the court. The lawyers that are always making frivolous petitions, who are involved in forum shopping, the lawyers who are perpetually looking for ex parte injunctions and wasting the time of the court. Now, who disciplines the lawyers? Because lawyers are also just as guilty as the bench.
Thank you very much. And that's why I was very clear that I was speaking to my constituency, both lawyers and judges. And that's why I said, you must best well be a lawyer before you become a judge. Reuben, there's no doubt about that. Professional ethics is gone in our country. You now see lawyers, senior lawyers, going to court to fight who should be a client representative. When we are taught in the law school that a lawyer, you remain in your office and you are brief in your office, what do we find today? There's collapse of ethical values. Lawyers, my colleague, for example, look at the one of the echo of the plan to stop the use of the vivas. Should NBA have to wait for a petition before we into this matter? Because they are lawyers having their own stamp with Supreme Court number who fight these processes. Should NBA have to wait? No. Lawyers are responsible. Who has gone to fight the matter in court? Lawyers. The issue about corruption, who are those? Lawyers. They are the one responsible. Reuben, we have got to a point. Look, that's why, I spoke to a number of our senior colleagues who are in the bench, serving, and those who have been retired. I keep appealing that if you hear what politicians say about we lawyers, about judges, sometimes you feel ashamed that they tell you that, look, please, all we want for you to do is just obey this order. By tomorrow, 12 o'clock, we are going to get an order. Everywhere, ex parte order, people are just getting order the way they like. It is now the intent in our country. Politicians now boast that you must have judges as your friends. The worst of all is that having served, look, we have made argument for the welfare. The welfare of judges will continue to do so. They are in poor environment. But the question is, how are they exercising their independence? My professor of law, University of Lagos, Professor Aki Oyebode, in his book, Law and Nation Building, he raised the question there. Can we really say that the judiciary remain the hope of the common man? That has been a question, and perhaps a debate for another day. But from what we can see, even the big men in society cannot even, don't talk about the common man. Can they assess the cost of justice in our country? This is what is going on. Reuben, you see, Supreme Court justice upon Supreme Justice that have left the system, they kept telling us what we know, that corruption had permitted everywhere. This is terrible. Because of vested political interests, justice no longer matter anymore in our country. The pyramid of our values is now upside down. Dishonesty is now on top. We now have a situation in our country, Reuben, that those who will do the wrong thing, they are the one that will tell you, go to court. They challenge you to go to court. We have got to a level, Rufai, in our country, where people forge document. They go to court to obtain court order. To get judgment, they forge document. People can even lie on oath, because today, telling lie is seen by our leaders as a sign of sophistication.
So how do we punish them?
This is where we are. And that's why I'm calling on my colleagues. That's where we must still go. Because the judiciary still remain the essential pillar of the democratic process. And that is why when Justice Robert Jackson of the U.S. Supreme Court already said, look, so, no matter what, so the court must always stand tall. Even though we know, as the Australian scholar will say, that, look, the law is as declared by the judge, and justice is not guaranteed except for the personality and integrity of a judge. We want people to stand tall and mighty in defense of our democracy.
So how do we punish them? Because you see, yeah, we can do
this
moral
morning.
suasion.
This morning, I am calling first on the NBA to go and find out, get the process that has been filed in any courts to stop the use of beavers. Get that first. Now, the NJC, the Chief Judge of the Federal High Court, please, any court in the land where it is be reported that such a matter has been filed, a matter that had the potential to destroy the republic, because INEC is preparing now on the basis of the use of beavers by virtue of Section 160 of the Constitution of the land, supported by Section 50 of the 2022 Electoral Act, supported furthermore by Section 84, subsection 15 of the Act, that no court of law shall give an order stopping the holding of election. Okay. But if history is the graveyard for contending opinions, we must remember it had been done before. And so we are of the view that NJC, NBA, all well-meaning Nigerians, please let us speak to ourselves. We must get it right, because the greatest promise of democracy is periodic election. Good enough, the 2022 Electoral Act had made it possible to return power to the Nigerian people. 2023 should be about the people who must exercise their franchise, going to their respective offices. What is the office of a voter on election?
Just about 2 minutes
to go. Polling unit.
And I wanted to ask you this question. The NJC that you referred to, even the NJC is in need of reform.
Correct.
So I wanted to ask you, a few days ago, Mr. Mohammed Aruna, an INEC commissioner, said that it is not illegal for a candidate to take part in 2 primaries. So you can go and run at a presidential primary, and then later you say, oh, you want to be a senator, you go and do that. But you were on record as having said no, that in fact, one of the innovations in the electoral 2022 is to correct that. But do you now share Mr. Aruna's views?
With the greatest respect to my former senior colleague, having worked together, his position is totally misconceived. After I made that observation on his sister station, the Federal High Court in Umuahia referenced that section in delivering a judgment. I am not aware of any other court that has decided contrary. But for the benefit of Nigerians, the argument of Haruna and others, and they are entitled to that, just as my own understanding of the law has declared clearly. Section 115 is intended to prevent people from buying two nomination forms, because you buy nomination form to become a candidate, to aspire to be a candidate, and that's why you buy the form, you fill it, you sign it, you submit it, you are screened. Their argument that no, you must first become a candidate before you fill INEC form. You know, the form used to be from 0007 and 09. Those were the forms before. We are now having from EC9 and EC9B. The INEC form you fill, Ruben, Nigerians, is a form that is free. You don't pay. You cannot say that somebody who already become a candidate will willfully go and fill a form, which is the argument. The argument that when you become a candidate and you fill that form, that you have seen to have violated section 115, that is not correct, because no candidate, after being a candidate, will now, recklessly, willfully go and fill a form that is free. INEC form is free. It is that form that you buy with a view to blocking a particular position that the act is referring to. In any case, we could see some element of inelegant drafting, because the section 115 says that a candidate who signs, a person who signs a nomination paper or result form as a candidate more than in one constituency at the same election. Now, Ruben, no candidate signs a result sheet on election day. Usually that one is done by party agent. You can see that part of the section is redundant. And that is why if you go for the under section K, the law has said even attempt to do that form, to buy that form, should be treated as the offense itself. Haruna and all those who are making that argument, they are not correct. Okay. Because to say so would mean that this section is not intended to punish anybody at all. Because after becoming a candidate, it's not expected that you go and fill two forms. It is not possible. It is the nomination form you buy that is intended here. It should be right. And I think that we have a opportunity of the Supreme matter getting to Supreme Court so that Supreme Court can pronounce on it. But for now, my message to our colleagues as a final closing remarks here, that the future of this country is in our hands. There is anger in the land. People are not happy. The level of discontent is high. Nigerians are fired up. They are waiting to exercise their residual sovereignty on February and March. Do nothing. Don't do anything to undermine it. Those who crave the honor of a king must not break the law of the land. Call justice by a true name and not by any other name. This is the call I'm making, so that we can build a society where there will be opportunity for all and responsibility from all.
Okay, on that note, Mike Igini, we would like to thank you very much for coming to the morning show again.